Let me welcome all of you to this wonderful occasion, and particularly welcome David's family, Laurie and Annalise, I think, are here somewhere out there. There they are, I see them. And Mr. and Mrs. Roland Straub are here, and Mr. Straub will be on the stage in a short while. Senator Max Cleland is also with us, a special guest of the Bedermans. Welcome, Senator. And all my colleagues and David's colleagues, thank you for being here. There are a lot of enjoyable occasions that deans have the privilege of standing up and delivering of themselves, and this has got to be the most enjoyable of them, I must say. So I'm honoured to say just a few words that will heap all of this praise on David. He's a modest man, but he will have a whole lot of praise heaped on him, and it's all well-deserved. In fact, all of us in the law school and all of us in the academy have been shouting at me for years now. It's about time that David was invested with a chair. So this really is it is time, and it's marvellous to be able to do it. David's work is astonishingly broad and deep. He has, for example, just this year published 2 books, and throughout his career he's kept up a torrid pace of scholarship. Now, the skeptic always looks at such a list of scholarship and says, oh, it's long, but it can't be deep. Well, of course, as you know, it's as deep as it is long. It's remarkable. And for all of that, David is the best of law school citizens. We all know, his colleagues know, that he's a top-flight teacher, keeping very much in the tradition of Richard Dornberg, the former holder of the Gear Chair. He performs in the classroom at the highest level. And he's also a wonderful citizen. It should be known that I've been quite merciless with David in asking him to do all sorts of things to help in the development of administration of the law school. For example, on the appointments committee, I think he, at almost every meeting, puts all of us to shame with his thoroughness and willing to take on new tasks of that busiest of committees. In addition to all of this, in addition to his teaching, to his scholarship, and to his service, he runs a high-level appellate practice, proving that he really is a superman. In fact, I suspect he's probably cloned himself several times over in order to accomplish all of this, especially when you consider that he's a well-rounded person. He's a great family man, as Laurie always tells me. So there's got to be some weakness, I've probed for this weakness. And perhaps it is that his golf and tennis games have suffered with all of these achievements. Or perhaps it is that the decor of his office is not quite up to scratch. But they're not fatal weaknesses so far as the award of this chair is concerned. As you know, to be awarded a chair is one of the recognitions of a distinguished career. We all know that post-tenure there aren't too many landmarks that we find that signal this achievement. And it's difficult as a dean in the sense that this faculty is comprised of outstanding and distinguished people, yet we have a paucity of chairs. My task is, of course, to go out and get more so we can recognise all of my distinguished colleagues. It's a great delight that Mr. Roland Straub had the insight 21 years ago to provide funding for the GEAR Chair. And I know that he's delighted to recognise that it is now being filled by one of the nation's premier international law scholars. As I mentioned, Mr. and Mrs. Roland Straub are here today. Mr. Straub was the benefactor of this chair when it was established, and he is one of our most distinguished LLM graduates. He graduated with his LLM in 1987 in international tax, and he's had a stellar career in law and business. No doubt inspired by the work that he did here at Emory, he then practiced corporate and tax law for 15 years in Switzerland. He has been on the board first of a company called Optical Publishing, now it's Optimus, and he assumed the responsibility of Optimus in 2003 after serving on that board and being chairman. He's now the president of that company. The company is, I'll probably get a further description of this later on, but from what I can gather, is a company that looks at this burgeoning world of information and tries to break down barriers, making information more accessible, making information more easily disseminated, recognizing that this information is held in different platforms and there are natural barriers to it that need to be broken down. So through technological innovation, this is work that the company is doing. So we're delighted that you've traveled here from Colorado to be with us on this singular day. Mr. Straub is going to just say a few words about the foundation and inspiration for the GEAR Chair. Let me welcome Mr. Straub.
Good afternoon. Indeed, I'm very pleased to be here today. And it is exactly 21 years after I received my LLM here at Emory. It has been a pleasure not only to come here today, but it has been a pleasure to be associated with an institution like Emory over the many years. And I can assure you that my contacts to the faculty members that are now as high up as in the Human Rights Court in Den Haag, and other distinguished members of the faculty that have either traveled on or have crossed my life path again, always have enriched my life. And because of that, I would very much welcome this opportunity to already say and state something which is primer to all what is to follow. And what is to follow is to give you all a little bit of background of why is it that a Swiss brought up in the institutions of public education actually got so inspired by private education in this country. But the opportunity, and what I welcome so much, is the fact that with David Bederman, we will have somebody invested with the KH GEAR Chair that I truly believe go far beyond the formalisms and the artificial boundaries that we see ever so often erected in law. And maybe that is a little reason why, after 15 years, it took my personal interest to go into business rather than to stay with law. But when I looked at the body of the publications of Dr. Bederman, I had to say, yes, there is academia out there that really sees that there is a boundary overcoming new world especially in private law, that we all need to embrace. But let me explain a little bit about my grandfather, after whom this chair is named. Dr. honoris causa, Karl Heinrich Gierschlüter, was a distinguished Swiss industrialist. He has been brought up, and his schooling was in Zurich and in Lausanne. He did the Polytechnic Institute in Zurich. He did submit his PhD at the University of Dresden. And he was traveling the world on the brink of the 19th to the 20th century quite extensively. Among other things, he did long trips in America and so in all of Europe. Not surprisingly, he decided Switzerland was really not up to scratch at the time concerning the Industrial Revolution that was going on. And he took his first work assignments in Manchester, which had a very flourishing and very quickly advancing chemical industry. It was only upon the insistence of a school friend of his, Dr. Landis, that he returned, repatriated to Switzerland. Once there, he became partner in the electromechanical workshop, really what it was, that Dr. Landis had acquired several years before. Together they set out to build this into a meaningful business. In 1946, when my grandfather died, he could look back and really truly say he had achieved his life dreams. He had built a company that was active in the distribution of electricity, in the measurement and counting of electricity, and in the nascent, what you call building control industry. The company was active in almost all of Europe's countries at the time, and was exporting its specialty products to India, Canada, and China. My grandfather did a great work, and I'm very, very grateful that it was laying the foundation for me to do what I wanted to do most, to learn, to be a cognizant citizen, and to really endeavor out and see what this world can offer for people who really want to succeed in it. After my grandfather's death, it was roughly 40 years later that I had the opportunity and also the privilege to come to Emory and to be one of the first LLM students at this distinguished institution. It was fun, let me tell you that. It was a lot of work, but it was fun. We were, I think at the time, we represented 12 nations, as far away as national China at the time. And we were a small group, very intensive, lots of debates. Remember, it was the Jimmy Carter administration, so there was naturally a local incentive to it. And for us all, it was a huge expertise, a huge intake that we could come to an institution like Emory. Emory was emerging. Emory was at the brink of becoming a really, truly famous institution. And Emory has always been a very solid and very founded institution. That was the moment when the international exposure really started to focus. And Thomas Bergenthal, who was not only a teacher of mine, but also a good friend, suggested at a dinner that this crowd of international students should try to do a sign as a kind of ignition of something to come. And I took that up and I said, I inherited the privilege to be free and to pursue teaching and learning as I see fit. I was very impressed by the stress and also the meaning that private education had for the students that were striving to come forward in life. And that was the main motivation for me to make that endowment. And what I have seen that developed over the last 20 years has never let me regret that gift for one moment. The investiture of David Bederman today marks a new chapter in the short history of KH Chair, and I dare say that everything points to a very fortuitous and synergizing coming together of several components. The mind of an exceptional scholar at a great institution with knowledge and a view of law that reaches far beyond functional and national boundaries, seeking to capture the constitutive elements of law and in human culture. Thank you very much.
Thank you. Before calling on David to deliver his inaugural lecture, we have a formal investiture procedure, and Mr. Straub and I will hand this letter to David to officially invest him with the chair. Thank you.
Dean Bartlett, Rowan Straub, honored guests. I see so many of my family, friends, colleagues, and students here today. I really am touched, and I want to echo something that Rowan said just now. I am immensely gratified and humbled to receive this honor. Too often in the Academy, we lose sight of the privileges we have. I am so extraordinarily grateful for a profession that has allowed me to have the wondrous experience of teaching bright young students, and they get younger every year, it seems, of devoting my life to public service and law reform, the freedom, as Rowan said, to pursue one's intellect and one's studies in one's chosen field of endeavor. I really am touched. I owe an immense debt of gratitude to this institution. I've been here at Emory for 17 years. It's been a wonderful home. I want to pay tribute not only to Emory, but to my country and the times we live in that make this freedom, which I think is going to be a central part of my lecture today, so important and so meaningful for me. Today is Veterans Day. And we need to remember it's a holiday created in remembrance of an armistice that ended one of the bloodiest conflicts in global history. And the themes of my talk are about responsibility and freedom in a global order and how it affects our everyday lives as participants in markets and commerce, as citizens and statesmen, and as those concerned with the future of humanity in the world we live in. These issues are on our minds a great deal today. There are challenges that face the country, the world, the new administration. And what I propose to do in this lecture is to ruminate on what may be regarded as a strange example of law among the lawless, a code of conduct among pirates and thieves. It's a strange topic, and I've called it the Pirate Code. But I hope at least at the end of these few minutes together, you'll see how at least I regard this as affecting our thinking about the private international legal regulation of aspects of contemporary globalization. First, I want to say a few words about private international law, and not just because It's the formal subject matter of the chair and endowed professorship I've been invested with today. And I am immensely grateful to Rowan Straub and his family for recognizing this as a distinctive area and pursuit in the law. For nearly 2 centuries, international law has been very formally divided into 2 branches. One of these we call public international law, or the law of nations. The other has been known by the phrase private international law. And it was a concept, an idea that was invented in the early 1800s by individuals as diverse as Justice Joseph Story of the U.S. Supreme Court and Friedrich Karl von Savigny, a very prominent German legal philosopher. And the essential elements of private international law is to look at relationships, statuses, and transactions that cut across national boundaries. Private international law looks at topics like conflicts in law and aspects of international economic relations between purely private transnational agents. Now, this division between public international law on the one side and private international law on the other has been with us for many years. But one of my themes for today's talk is that the boundary lines, the formalism, as Rowan mentioned in his remarks, is starting to break down. And this is having important consequences for us as citizens, as participants in markets around the globe. Now, one of the ways that we look at globalization today, and globalization is a word that's much on our minds, but really, if you think about it, private international lawyers have been thinking about globalization for close to 200 years. This is not a new concept for those working in this area. And what we're starting to realize is a number of developments that we hadn't realized their significance are now starting to blur the boundary line between the public part of public international law and the private part of personal relationships that cross boundaries. We're starting to see the creation of global institutions like the World Trade Organization that impact the everyday lives of Americans on basic issues of access to goods and services. We're starting to see competition between countries to regulate activities of markets and businesses. We're starting to see that in the realm of dispute settlement, that what had traditionally been the province of countries in governing dispute settlement mechanisms are increasingly being dominated by individuals and corporations as they seek to vindicate their rights in international law before forums as diverse as the North American Free Trade Agreement, the World Trade Organization, as I just mentioned, institutions created under bilateral investment treaties, and other similar types of forums. So we are really seeing a change in the landscape of international law today. And one of the reasons that I'm here is to explain how this really does matter to us. In part, the fiction, this rigid boundary between public and private may never really have mattered too much. At one point in our history, it may have been significant. But today, in a world of increasing globalization, I would submit to you that to embrace a distinction between public and private international law can have some dangerous consequences. Now, nowhere, I think, is this more evident than in studying actors at the boundaries and interstices of national jurisdictions. And no time in human history, I think, are we seeing these cross-jurisdictional effects across boundaries. Globalization, it's often said today, is unique and irreversible. I don't necessarily believe that. I'm not one who regards globalization as being a strictly contemporary phenomenon. In truth, there have been many periods of globalization, and in a moment I'll explain what some of those are. But we have to be mindful, especially in the current financial crisis, that we have experienced as often periods of deglobalization than we have of intense unification of the economy and society on the planet. The Great Depression of the 1930s was just such a deglobalizing event, and obviously we need to take care that the current economic circumstances do not replicate that unhappy time in human history. The study of private international law, to close this theme, is as much a survey of the failure of regulatory regimes for transnational enterprises, and this lecture explores one example of a case study of what needs to be avoided in order to make globalization work. Now, my case study involves what I regard as one of the most significant areas of intersection between public and private international law, and that's what deals with multiple conflicting uses of ocean space, whether for security, fishing and hydrocarbon exploitation, navigation and commerce, or environmental protection. And this has been so for nearly 500 years. And like international law broadly, the regulation of ocean space has also been divided into two branches: a public international law branch that we call law of the sea, and a private international law branch that we call admiralty or maritime law. Nowhere on the planet are conflicts involving private legal actors more apparent and more challenging and dangerous than on the oceans and seas beyond the national jurisdiction of coastal states. There was a famous debate in the 17th century between a Dutchman named Hugo de Groot, who was better known by his Latin name Grotius, and an Englishman by the name of John Selden. And they argued over whether the seas should be open to all who should seek to use them, or closed in favor of coastal states or maritime power interests. And this debate has conditioned the way we think about this subject to this day. It was an argument that Grotius and his notion of freedom of the seas, his notion prevailed. And it remains a centerpiece of U.S. foreign policy and a bedrock principle of global economic and trade relations. But freedom has a dark side. And if the world's oceans and conduits of trade are a global commons owned by none but used by all, they can be affected by what Garrett Hardin called a tragedy of the commons. And reduced to its essence, a tragedy of the commons is where a common resource is depleted and degraded precisely because it is not owned and managed by a single rational actor. Indeed, in some situations, the rational course, and I put that in quotes, may be to deplete or degrade the resource before any other common user does. Think of a New England village green and the incentives of the townspeople in that village to add sheep onto the green beyond the limits of pasturage. It's kind of a race to the bottom, as we sometimes say. And it's a race where there can only be one short-term winner, but never any long-term winners. A corollary of this tragedy of the commons is that under the rubric of the freedom of the seas, you can get large swaths of ocean territory that can become lawless. And that brings us to my somewhat fanciful title for today's lecture, the Pirate Code. Because piracy has always been the scourge of freedom of the seas. We know that pirates have always challenged a traditional order for the oceans. And by piracy, I simply mean acts of theft and depredation on the high seas beyond the national jurisdiction of any state. That sounds very formal, but you have to understand that piracy is what it is precisely because the perpetrators seek impunity by locating their unlawful activities beyond the reach of any national law enforcement or authority. This is why piracy has always been regarded as an offense within the universal jurisdiction of states to prosecute and punish. We know that pirates are, according to the Latin, hostis humanus generis, the enemy of all mankind. And in a famous case called the Ambrose Light, decided by a U.S. court in 1885, the court said that pirates attack the rights of all mankind and menace with destruction the lives and property of all who resist their unlawful acts. And universal jurisdiction over pirates is the only other remedy except open war. A pirate has no country of nationality that can afford him protection, and therefore a pirate is subject to arrest, trial, conviction, and sentencing by any national authority. I need hardly add that the traditional punishment for piracy is death. Now, it seems quaint in this year, 2008, to talk about piracy. But recent events have helped me, at least with the relevance of this talk, and I'm grateful for them, if one can be grateful for such things. But the truth is, the incidence of piracy has always risen and fallen in relation to globalizing trends. And there have been many great ages of globalization in human history, but during each of these periods, piracy was a popular pastime for those who sought to challenge an emerging global order, especially those imposed by leading hegemonic states, whether it was the Roman Empire, Spanish Empire, British Empire, or today's Pax Americana with the United States as the world's sole remaining superpower. And I want to be very clear here. Despite the romantic connotations that are continuously afforded to pirates in the popular media, let us not forget one very important thing. They are criminals. Indeed, they are the ultimate international criminal, and it is no surprise that transnational criminal networks can find opportunities in times of intense globalization. And that is why piracy is alive and well today. The International Maritime Organization, which is the London-based UN specialized agency devoted to shipping safety, actually keeps statistics on this question. And it has characterized parts of the world's oceans, including the Caribbean, the South China Sea, and the Straits of Malacca, as pirate-infested. Pirates tend to focus their illegal activities in proximity to lucrative vessel traffic lanes, where national law enforcement and Coast Guard authorities are weak. And make no mistake, pirates have gone high-tech, with GPS positioning and real-time surveillance capacity, fast Zodiac boats, and even helicopters, a modern array of arms and munitions. Pirates can overwhelm all but the most heavily defended and motivated vessel targets. Now, the brazen character of contemporary piracy has been reached public notice with the activities off the coast of Somalia in East Africa in the recent weeks. And Somalia sits astride one of the most significant vessel traffic lanes in the world, and exploiting the absence of anything remotely resembling a strong or coordinated government in the region, Somali pirates have executed increasingly audacious ship captures, including the ransoming of crew and passengers and the sale of a vast amount of stolen property. In fact, there was a recent face-off with a Somali pirate against some of the great navies of the planet after the pirate had captured a Ukrainian freighter full of military equipment. What is perhaps most appalling about this situation is that they actually succeeded in arranging their own release with part of the negotiated ransom. Now, while it would be tempting for me to use my lecture to opine on the sad state of affairs of anti-piracy enforcement and the lack of effectiveness of the principles and application of universal jurisdiction, such is beyond the scope of this lecture, which is supposed to be devoted to questions of private international law. But as I think you've already gathered, the public and private dimensions of international law now mix and intermingle in surprising ways. And I'll return in a few minutes to the impact that transnational criminal enterprises have on global order. For the moment, though, I'd like to concentrate on the interior dimension of these networks, how they organize and govern themselves, in short, why law may actually matter to a pirate. Regrettably, while there's some anecdotal information on how Somali pirates organize their operations and to the extent to which they collude with weak governments in their country, there's not much data about what Carl Llewellyn or E. Adams and Hobel called the law habits or law ways of these pirate groups. For that, we're going to have to return to the golden age of piracy in the Caribbean and the Spanish Main of the 17th and 18th century. Now, this has been immortalized of late as both a Disney amusement ride and trilogy of movies. To call them films would just be wrong, I think. The Pirates of the Caribbean. Now, the Pirates of the Caribbean obviously envisions a highly idiosyncratic and romanticized vision of buccaneer law, life, and mores during this period. A consistent theme of these movies, starring Johnny Depp as the indomitable outlaw Jack Sparrow, is that the pirates portrayed seem to conduct their depredations in accordance with something called the Code of the Order of the Brethren. The pirate code appears to govern the bonds of those engaged in a piratical expedition, the captain and crew of the ship. The code may also prescribe the proper conduct of relations between pirates and non-pirates, including a modicum of due process for those that are captured by pirates and who are either to be ransomed, marooned, or killed, what is called parley in the movies. Now look, I do not want to vouch for the historic accuracy of Disney movies in their general respects, but I can warrant to you that pirate codes did exist and actually are quite well documented. Beginning in the late 1600s, buccaneers in the Caribbean began operating under a set of rules called the chasse partie, or charter party, or more evocatively known as the custom of the coast, or the Jamaica discipline. And whether viewed as an aspect of customary law or a trade discipline, the pirate code became known simply as the Articles of Agreement, the consensual contract entered into by participants on a piratical cruise. The articles were sworn by all crew members, either on a Bible or before crossed swords or pistols, and they were posted in a prominent place for all to see on board the ship. Pirate articles may have actually been modeled on those earlier adopted by privateering expeditions. And the only thing that distinguishes a pirate from a privateer was something called a letter of marque and reprisal, which is issued to a privateer by a legitimate government, authorizing the vessel to engage in captures on the high sea and requiring that the captures be properly adjudicated before a duly constituted prize court. In any event, we have extant a number of complete sets of pirate codes. So, for example, we have the pirate code of the Welsh buccaneer Bartholomew Roberts of 1720, those of Captain John Phillips for his ship Revenge in 1724, and those of Captains Edward Lowe and George Lowther for a combined expedition in 1722. A partial code from Captain Henry Morgan is preserved in a 1678 volume called The Buccaneers of America. A careful review of these texts reviews a number of common features for the private law ordering of pirate life. Not surprisingly, much of the content of these pirate codes concerns the internal discipline of the pirate ship. And perhaps somewhat interestingly, a pirate captain's major preoccupation was the promotion of the good morals of his men. For example, Captain Roberts' articles prohibited any gaming at cards or dice for money, and that lights and candles be put out at 8 o'clock at night, and that if any of the crew after that hour still remained inclined for drinking, they were to do it on the open deck. These articles also indicated that no boy or woman was to be allowed amongst the ship's company, and any act of seduction directed against one in disguise was to be punishable by death. Captain Lowe's articles punished drunkenness in times of engagement with an enemy. Captain Phillips's code prescribed that any man that shall strike another shall receive Moses' law on the bare back, 39 stripes with a cat o' nine tails. Now, certain rules of internal discipline were simple prudence and safety, such as Captain Phillips's code provision that no man shall snap his arms or smoke in the hold without a cap to his pipe or carry a candle lighted without a lantern. Now, perhaps most significant of all for a confederation of cutthroats were rules prohibiting thievery. In Captain Roberts's code, a strong distinction was made between acts of theft directed against common property as opposed to that of individual crew members. In cases where a member of a ship's company defalcated or embezzled significant items from a captured prize, something more than a shift of clothes, but more than the value of $1 in plate, jewels, or money, the punishment was marooning. And marooning, according to Captain Phillips's articles, meant being landed in a remote, uninhabited location with only one bottle of powder, one bottle of water, one small arm, and shot. The obvious implication being that the condemned crew member would prefer a quick demise to a slow, lingering death by starvation or thirst. But according to Roberts, if a theft was only betwixt one another, between crew members, the victim contented himself with slitting the ears and nose of him that was guilty and set him on shore, not in an uninhabited place, but somewhere he was sure to encounter at least some hardships. So in addition to these rules of internal discipline, certain norms were prescribed in pirate codes for the handling of common or public goods. All signatories to a pirate ship's articles were to have equal title to fresh provisions or strong liquors at any time seized, and may use them at pleasure unless a scarcity made it necessary for the good of all to vote for a retrenchment. Every crew member covenanted to keep their pistols and cutlass clean and fit for service. Pirate codes also had detailed rules for the distribution of income, and these rules read rather like the contemporary articles of partnership for law firms or accounting firms. And the essential purpose of a chasse partie was to regulate the distribution of gains and the allocation of losses among the joint venture enterprise. It was in this respect that the notional egalitarian features of pirate codes disappeared. Not all pirates, it seems, were to be treated equally. According to Captain Roberts's articles, he, the captain, and his quartermaster received 2 shares of any prize, while the sailing master, boatswain, chief gunner, a share and a half, and other officers a share and a quarter. And this kind of allocation was replicated in Phillips's and Lowe's codes. What is remarkable, though, is that even though these distributions do not reflect some true form of pirate socialism, they were far more egalitarian than the prize or booty distributions prescribed by contemporaneous acts of Parliament for the Royal Navy, or later by Congress for the U.S. Navy. In those instances, masters and commanders of warships received nearly 10 to 20 times the shares of those paid to common or ordinary seamen. So maybe there was something to the pirate life, at least for the possibility of receiving a handsome reward for ill-gotten gains. If pirate articles of agreement prescribed a common discipline, protected common goods, and directed energies towards a common goal, they also ordained a common welfare. A little appreciated aspect of pirate codes is their strong embrace of social solidarity, a progressive sense apparent centuries before poor laws in England and Social Security in the United States. Captain Roberts's articles provided that no man shall talk of breaking up their way of life, their pirate way of life, till each had shared 1,000 pounds. If in order to do this, any man shall lose a limb or become a cripple in their service, he was to have $800 out of the public stock, and for lesser hurts proportionately. So what we see here is kind of a weird commodification of injuries in these pirate codes, reflecting the commercial and criminal nature of the piratical enterprise. But these provisions are somewhat at variance with what has become the most famous provision of pirate codes, at least according to Disney's Pirates of the Caribbean: those that fall behind get left behind. Pirate articles of agreement do not reflect a warrior code, unit cohesion, or battlefield element that is an essential part of the ethic of our armed forces in the past or today. On this, of all days, do not confuse a pirate code as a pact among warriors. There is no honor among thieves. But just because pirate codes may be immoral should not disqualify them from examination by legislators, judges, lawyers, and law professors. Pirate articles of agreement reflect a very self-contained body of law for participants in a common enterprise, quite literally a floating vessel on a sea of criminal mischief. But to count as law, such codes must have something else, what H.L.A. Hart called primary rules of obligation, some way to recognize new rules of order, to create new law, and to resolve disputes among the participants. And pirate codes are no exception in this regard. The first article of Captain Roberts' code simply provided that every man has a vote in the affairs of moment. Now, this is no crypto-democracy at work. Pirates were not a classical Athens under sail. An affair of moment may have referred to the general direction of the piratical enterprise, but the day-to-day, hour-by-hour, minute-by-minute decisions were made by the captain who was in civil command of the vessel. And although pirates did not operate under naval discipline, indeed in many respects pirate codes sought to differentiate a pirate way of living from normal seafaring, they did recognize the necessity of leadership and the necessity of obeying commands. There was one last vital rule of recognition, and that is that pirate codes notionally applied only to buccaneers. There had to be an affirmative act of allegiance to the articles. There had to be a mutuality of obligation in order for the pirate code to be operative. Now, if you think about this, this is the essence of most private international law regimes, which attempt to order contracts and joint associations, whether they be the family unit or a business enterprise. And if you think about it this way, pirate codes certainly qualified as such. We know today that conflicts of law rules give cross-boundary recognition and extraterritorial enforcement for private arrangements. But inasmuch as one of the purposes of pirate codes was to prescribe uniform regulations for a buccaneer life, they undoubtedly also had the effect of harmonizing pirate operations and facilitating cooperation amongst what would otherwise be disparate forces of cutthroats. All right, but that begs the question, were pirate codes, properly speaking, law? As Captain Hector Barbosa in Pirates of the Caribbean, Curse of the Black Pearl, famously quipped, and I will not try to replicate his accent, the code is more what you'd call guidelines than actual rules. Despite his observation, the most useful way, I think, to regard pirate codes is as a customary regime. Just as merchants have a body of informal, unenacted law to govern their contractual ordering, what we call the lex mercatoria, and just as there is a corpus of uncodified private admiralty or maritime law that we call the lex maritima, why can't there be a lex piratica, an unwritten law for buccaneers? And this gets to a question that has puzzled law students and lawyers for many years. Is all law derived ultimately from legislation or administration or adjudication, or is it also formed from the informal usages and understandings that are considered to be legally binding by those who practice and observe them? And traditionally, we've called such usages and practices customary law. One peculiarity of modern legal studies is that we don't give much reflection to custom in contemporary legal culture. From the very first day of law school, students reflexively assume that all law must either come from legislators or from judges. And so law becomes a top-down construct, very much in fulfillment of John Austin's vision of authoritative commands. But I would submit to you that law is as much made from the bottom up by relevant communities. And as I've just mentioned, the lex mercatoria was for millennia used by global communities of merchants to regulate such aspects of trade as contents of bills of lading, cargo insurance for ocean transport, letters of credit, and other forms of international documentary transactions. But isn't there something more that makes a community practice a binding custom? Customs can be both good and evil. How do we distinguish between them? Is a custom binding even before it's been recognized by a court or legislature? The best illustration of this conundrum that I know of is a story told by our dear departed colleague, Professor Harold J. Berman. Hal told a simple story, one that said much about him as a clever teacher, an insightful scholar, and a devoted family man. As many of us know, Hal was married to his wife Ruth for 66 years before he passed away. According to Hal, every Sunday for those 66 years, Hal would prepare a lunch for Ruth, provided they weren't traveling away from home. By any measure of consistency, 66 years, and duration every Sunday, this was an established usage and custom for a particular community, the Bederman household. But was this a binding custom? Was it law? What if, Hal mused, one Sunday morning he just didn't feel like making brunch, or he was angry at Ruth and didn't want to make a meal? Could Ruth have sued him for specific performance? Had an informal usage ripened into a legally binding custom? Well, these are great questions, and they are relevant to the question of whether a pirate code rises to the dignity of customary law, a time-honored, consistent, and ascertainable usage of a community that is followed out of a sense of legal obligation. Should it matter why a practice is followed? Does the usage have to reflect a mutuality of consent and interests, or is it enough that it be reasonable? And how does one establish the reason behind a particular provision of a pirate code? And most important of all, is there a place for moral judgment here? To the extent that the pirate Articles of Agreement perpetuate an evil practice, isn't that enough to condemn the entire project? Now, in the closing minutes of my lecture, I want to move from the sublimity of the Bederman family to the moral ambiguity and juridical ridiculousness of a lex piratica. And we come to the central question posed by this lecture. Can a lawless transnational private enterprise be nonetheless governed by law? Should private international law recognize the customary norms and usages of such criminal networks? I believe the answer is yes, but I want to be emphatically clear that I say so for no other reason than to assist the processes of globalization to defeat these criminal forces. And in this respect, it's vital to see pirate codes as reflecting a private international law of business associations, but we must not fall into the same trap as we have seen with the policies of this administration, of morally labeling these kinds of evil actors as a protozoan form of state actor, and their conduct as a war on humanity. To do so would be to convert criminals into combatants. They do not deserve that dignity or that treatment. I've already mentioned some of the aspects of globalization, and I won't repeat them again. And I've already mentioned that pirates, like many other forms of contemporary international criminals, are non-state actors. But one of the key things that we have to confront is that our reaction to international criminals has been largely conditioned by the artificial distinction between public and private international law. It is a distinction that in many respects has governed this nation's war on terror. It also conditions how we respond to other international criminal conspiracies. I will not give you the very depressing details of the scope of international crime. It is an appalling problem. It is one that, in many respects, concerns us as a detriment and side effect of globalization. And international organized crime in all of its different manifestations is a major challenge for our government in all of its respects. But international law's response to this problem has been typically and quite characteristically and unsatisfactorily the same. The reason that's unsatisfactory is, again, because of this traditional divide between public and private international law. Transnational criminals can only be suppressed by public international law tools. Now, a few minutes ago, when I discussed this artificial dividing line between public and private international law, if it were only the plaything of international law academics, no one would care. But when it actually gets in the way of effective law enforcement and policy, then it's high time to change our thinking. Transnational organized crime is hard to suppress in the same way that transnational business is hard to regulate. One reason is that the traditions of state sovereignty, often manifested in formalistic rules of jurisdiction, frustrate effective transnational law enforcement. One country's criminal process cannot extend to another nation. And even though a nation may exercise criminal jurisdiction over the conduct of its nationals abroad, that can often raise jurisdictional conflicts with other states. And as I've already mentioned, this implicates the central dilemma of private international law, ordering the status, relationships, and transactions of non-state actors across national frontiers. Why bother with reconceptualizing our response against criminal challenges to globalization? Why should it matter to use the tools of both private international law and public international law in this campaign and to turn criminal customs against them? One answer may lie in imagining innovative ways to address certain criminal elements. While I do not support the privatization of warfare and believe that our campaigns in Iraq and Afghanistan have suffered from the outsourcing of security functions to private operators, there may be an argument to be made in favor of privatizing some aspects of the fight against crime. Just as piracy was suppressed with a combination of naval and privateer efforts, we can see a similar move being made in contemporary times. Private international law gives us the tools for understanding this threat of globalization and confronting it in a way that is consistent with our democratic values and our fervent belief in the rule of law. If the United States, with its allies, could defeat the Axis in World War II and successfully contain communist regimes during the Cold War without losing our moral bearings, we can surely be triumphant in the war against terror. Such a conflict need not be perpetual, and it can be fought and won on our moral high ground. At this level of analysis, the global challenge of combating international crime merges into the great values of contemporary international law: protecting international peace and security, upholding human rights and dignity, promoting the commercial and creative energies of the world's populations. Essentially, this lecture has been about the dark side of globalization, the trends and processes of the New World Order that tend to subvert and upset settled expectations about the goals and opportunities for contemporary international law, both public and private. International law rules and institutions are attempting to alleviate and prevent aspects of transnational criminal behavior, if such can be ever regarded as a regular phenomenon or as an inevitable burden on the global commonage. How international law responds to this challenge is of immense significance for the future of globalization. Thank you very much. I am standing between you and a reception, but I've been told I can take at least a few questions. There are microphones at the back if anyone wants to ask any questions. We have one taker.
Thank you, David, for that wonderful lecture. I was curious, we know there's a debate raging about customary international law and its place in U.S. courts as a way to enforce certain international norms in domestic jurisdictions. And I was wondering if your perspective on the history of this sheds some light on what the approach should be in the United States to the incorporation of customary international law.
Well, thank you. It has been a contentious issue. Traditionally, international law, the sources of international law have been divided into two baskets. One is treaties, written international agreements, and under the Constitution, treaties are part of the law of the land, so they are applied with certain limits and restrictions by courts in the United States. But in the other bucket is what I think I referred to in the talk as customary international law, the unwritten practices of countries. And there's been a great deal of controversy about whether these, absent some affirmative act by Congress to incorporate these rules into rules of decision for U.S. courts, whether U.S. courts should directly apply them. There's an historical controversy, which I probably will not dwell about, and a constitutional one. I tend to be of the view that there are occasions where customary international law is an appropriate rule of decision. I'm not alone in that. The U.S. Supreme Court has as much said so on a number of occasions, that it's the province of judges to accept evidence of what the practices of countries, whether it be in a public international law sense or even a private international law sense of merchant custom, and to apply those rules. Now, we may disagree about situations where the executive branch takes one position about what the content of customary international law is, and should courts defer to the executive branch position. I think, as we have seen with the Guantanamo cases, courts, including the U.S. Supreme Court, don't often necessarily take as gospel what the executive branch says or characterizes as the content of customary international law. So I think this remains a crucial part of rule of law values for the United States, that our judiciary is independent. Where appropriate, it will defer to the views of the political branches and to the executive branch, which has the most direct say in the formation of customary international law. But otherwise, the judges and the courts will weigh in where appropriate with those kinds of decisions. Thank you. I did not address it, and you did not miss it, but I'm happy to address that. There will always be issues of coordination among law enforcement agencies. And there is an area of international law called mutual legal assistance where these issues try to get worked out. And the situation you describe is that in a globalized world, conduct in one part of the world may have impacts on another. And is it enough that a cartel in Europe might have antitrust impacts in the United States? Well, the U.S. has long taken the position that yes, and the U.S. will prosecute for that kind of criminal conspiracy. The Europeans initially resisted that. They didn't much care for the idea of what was called the effects doctrine in this kind of jurisdiction. But over the last few decades, European countries have kind of bought into this. So now you might have a situation of multiple or overlapping jurisdiction. I guess I'm worried less about a situation where you may have too many law enforcers as opposed to a situation where you may not have enough. I am satisfied that the current mechanisms in international law to kind of play traffic cop about who has priority to prosecute or to investigate can be worked out. What I'm worried about is that with certain forms of international crime, and obviously my selection of piracy was meant as a challenging metaphor, in light of, I was about to call them the pirates of Penzance, the pirates of Somalia, we can now really regard this as the serious problem it is. But I was mystified why countries that for years had indicated that piracy is a universal crime suddenly had qualms about prosecuting these individuals as criminals. And as I emphasized in my talk, the proper approach for dealing with these challengers to global order, whether they be pirates, whether they be international crime cartels, or whether they be terrorist organizations, is to treat them as the criminals they are and to use the tools that we have available to us. Now, if that means that we have too many countries lining up to prosecute, that's something that can be worked out. But at a minimum threshold, we have to make sure that at least one is prepared. And so with our friends, the Somali pirates, I was always perplexed that no one was essentially prepared to do that. Right, and again, I see the process of international law as a struggle for law. It is legitimate for countries to attempt to extend the limits of their jurisdiction to bid new rules of law. But it has to be effective when it comes down to law enforcement. And my concern with the Military Commissions Act was it confused a criminal kind of jurisdiction with a quasi-combatant, non-combatant distinction, which was unnecessary. The truth is we had the support of our allies to create a criminal trial mechanism to deal with the major perpetrators that we were holding in Guantanamo. And I won't speak, and I'm not, in truth, not sufficiently knowledgeable to know how many of the individuals detained at Guantanamo were or were not threats to U.S. security or to other countries' security. That's not the point. The point is, if we're going to effectively combat terrorism, using a model of criminal jurisdiction, we would have had the support of our allies either to use criminal prosecutions in the United States or some kind of mixed criminal approach or tribunal with judges from other countries. I don't think there would have been any lack of support for that. But the literal and figurative black hole that Guantanamo was, or certainly has now become, largely has frustrated United States policy and efforts for effective enforcement. Now, what the solution is obviously an issue that's now being debated not only in the last days of the Bush administration, but will be the first days of the Obama administration, and maybe we'll get an effective resolution. But it's one that I think the benchmark is not some fidelity to an ideology about international law or international relations, but the benchmark should be effective law enforcement. That was actually not the model, even though I alluded that was used in the suppression of piracy in the 18th century, something similar to that. Actually, a model that I've been thinking a lot about involves a form of common space and a form of common crime that we don't normally associate together, and that's cybercrime, computer crime. We ought to think of cyberspace as a kind of global commons. It's not a real place, of course, but it is a common resource that is managed through both private and public international law mechanisms. And we're starting to realize our vulnerability to cyber attack and to computer crimes. Governments have shown themselves singularly unable and ineffective to respond to this, even with very cleverly drafted statutes. And so one model that's been suggested is kind of a private enforcer model using creative energies of computer hackers, computer security specialists to monitor the internet and set up, for lack of a better phrase, a bounty system where if these kinds of forces could, either on a voluntary or other basis, suppress certain forms of cybercrime, that they receive some kind of an award. So it's more of a model, and again, let me be clear, I'm very concerned about situations where we enlist private bounty hunters, private operators that are engaging in what should be traditional state aspects of law enforcement. But in certain areas, like the one I just mentioned, I could imagine a collaborative system where these kinds of incentives are structured so that effective law enforcement could occur.
It remains for me, David, to thank you once again for a marvelous lecture, and I think it indicates to all of us that what a worthy occupant of the Gear Chair you'll be. One of David's most recent books probes the classical roots of international law. He's a scholar of such breadth. Now we have Disney movies, not films, as one of his sources. We have a reception waiting for us outside. Please join us there, and another round of applause for David Bederman.